The health and safety issue is a fine example, which is where you have your risk assessment for a building, and that's fine. It sits on the shelf. Hopefully, people are looking at it and they're working off that risk assessment every day. But when it comes to now putting any trade in, whether it's reactive work or planned maintenance, managers need to be taking that risk assessment off the shelf and looking at it, and it's seeing what they need to do to change that risk assessment to work under the current regime. Unless HSE have given dispensation, then all previous rules still apply. So, for example, LOLAs still apply. And it picks up what Roger was saying earlier. The rules still apply. Just because we're in COVID, it doesn't mean you can't do this or you can't do that. So I've just had a brain crash there. I've had 4 different thoughts all come into my head at once. I know what it was. This is the point. But this is the point, because every risk assessment is different, and it now needs to be changed individually. Every building is different, and every set of customers are different. Nigel's point. That you need to be addressing each building and each scenario individually and making a value judgment. And that point about justifying your witchcraft, why did you come to that conclusion, and recording why you came to that conclusion. It's reasonable to decorate, to cut the garden in the retirement one, but not reasonable in the other. By documenting it, at least you've then got a defence in the future if you get challenged on it. But it is that it's the danger with the webinar is that you get this. You're looking for that golden nugget, or that silver bullet, that one-size-fits-all solution, and it isn't. It is actually a series of individual decisions for each situation.
I think.
I was going to say that's why management professionals are professionals. That's the point of being professionals, isn't it? You're taking individual decisions.
You said 2 things there, Andrew, which I wholeheartedly agree with. But the first is that it's fact specific, and part of the reason for that is because the law as it stands and the guidance is so vague that it really has to be applied on a case-by-case basis. That I suspect the legislators have done that very deliberately. They put the onus on the individual. So what is essential will vary on a case-by-case basis, and if it ever did get litigated, it would be highly fact-sensitive. I'd have to prepare detailed witness statements from all of the individuals concerned to explain, why in this case it was essential. And I suspect there wouldn't be any one-size-fits-all case. I suspect the judges would say, on the fact of this case, it is or isn't essential, and really it would just boil down to individual circumstances, which is very frustrating. But in another way, I suppose it gives us the flexibility to make a decision. And recognises that everyone is different. And you said something else which I agreed with, and I can't remember what it was now. Oh yes, documenting, making sure that you document all of your decisions. Again, from a lawyer's perspective, if you ever end up with a reasonableness challenge in the tribunal, if you ever end up anyone challenging your decision to carry out or not carry out a particular set of works, what you want as a solicitor is everything to be carefully documented, so you can show the court or the tribunal your client's decision-making process. And and if you can't do that, you're in trouble.
And if you come back to the earlier points about communication, if you're communicating with your RMC directors, your freeholders, and your residents, if you're not straying too far from their wishes anyway, unless you have to, because they want the pool open and you can't, then you're going to minimise the risk of challenges, and also start to defray some of that legal risk by saying, well, hang on a minute, we all agreed on this.
It's interesting that we keep coming back to communication. It feels like the thread that runs through this, particularly in uncertain times. Nigel, what would you like to add in terms of planned maintenance, compliance, major works? What are you seeing in the market and hearing from members?
When we touched base on this before, sorry, it's an awful expression, that touching base. When the 4 of us had a chat a few days ago, I said I'd want to just quickly touch on cladding. It's been made very, very clear by the government that cladding remediation must continue at a pace, that COVID is not an excuse. So there's a lot of work going on there to try and get those systems up and running. There is the £1 billion fund, and details of that will come out in sort of mid-May, how to access that, and we're trying to liaise with government to try and make sure that they're a little easier to follow than the labyrinthine versions of the £200 million fund. So there's a lot of work going in the background there. But I think that's the, you know, what Roger was saying, to my mind, made a lot of sense about the major works. There are some that you can certainly, interior decks, why would you do that now? You're putting people close in close social proximity. It's something that frankly can be done any old time. Whereas a leaking roof, as Andrew says, the problem with that is it might be £5,000 to repair it today, but if you leave it a couple of months, it's going to be a £20,000 floor and refurb underneath. So it is tricky. One thing which is interesting, which the build to rent sector is doing, is instead of spatial distancing, time distancing. So they're sending contractors in at sort of 4 or 5 in the morning when there's nobody around. So there's, you know, there are ways around this. So yeah, I think that's my point. Get creative, get imaginative, move stuff around. Be aware of the consequences though, because one of the things we don't want as we come out of this is to find that we have no contractors left because they've gone bust because we've just tightened the purse strings completely.